Good afternoon, everyone.
Good afternoon, Your Honor.
How are you?
I'm great. How are you?
Good. Let's see here.
Good afternoon, Judge.
Good afternoon. How are you?
I'm doing good.
Good for Friday. Let's see. Hold on one quick second. All right, got it. Okay,
Judge, whenever you're ready to start, we're gonna start in courtroom 3.
courtroom 3, okay.
And after that is Annex, Your Honor, with position 14.
All right, good afternoon, ladies and gentlemen. My name is Judge Regina Mincy, and this is the Fulton County State Court Expedited Accusations Calendar. This is an expedited accusations calendar for today, which is April the 1st. And this calendar has cases in which individuals have been arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused these cases of the offenses brought against them, and the case has been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge. So we are able to address several matters, including bond, possible arraignment, or consideration of possible plea offer if one has been made by the state at this juncture. I will also be providing a reset date for those who are not out of court, don't get out of court, I'm sorry, get out of jail today. And I'm looking, I don't see it in the chat. What is the reset date?
It's April the 14th.
Okay. Normally it's put in the chat, but that's okay. April 14th.
I did, Judge. It's in the chat. I don't know why it's not showing.
Oh, okay. I don't see anything. I don't have anything in the chat. Stranger things have happened. We'll keep moving.
Okay.
Okay. All right. So we're going to begin by advising everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube. Want everyone to be aware of that, and also let the defendants on this calendar know and be reminded that you do have the constitutional right to remain silent. And remember that anything that you say about the facts, occurrences, and circumstances of your case can and will be used against you. So govern yourselves accordingly, listen to your attorneys, and follow their lead to make sure that you don't make any statements that might be against your interest later in your case. All right, we're going to go down to South Annex with position number 14.
We're starting over here in courtroom 3,
Oh.
Judge.
I'm sorry.
Yes, Your Honor, position 14 at the South Annex. Thank you.
Good afternoon, Judge. This is position 11. Ms. Smith Janice.
Hold on, South Annex. I think that we're starting with position 11 in courtroom 2, and then I'll come to you at the South Annex, okay?
Yes,
Hold
Your
for a second. Let me start with position 11. All right, thank you, Deputy. This is case number 22 CR 00191 D as in David. This is Janice Smith, is that correct?
Yes, ma'am.
And you're charged with 1 count of battery with the offense date of March the 30th, 2022. Pre-trial, do we have anything?
38 total. Last arrest was 2020 criminal trespass. It was a bind over out of East Point. 2017 trespass, possession of a weapon without a license, second or subsequent offense within 5 years of previous arrest. 2016 misdemeanor obstruction, criminal trespass, transactions and drug-related objects prohibited. Another 2016 arrest for the same thing. 2015 trespass conviction. Got 2012 probation violation, carrying concealed weapon, a knife. Shoplifting conviction, criminal trespass conviction from 2012. That's it.
All right. And is this Ms. Mitchell's case?
Yes, Your
All
Honor.
right, you may proceed. Go ahead.
Your Honor, we amended the accusation in this case, so it'll be a simple battery as it appears to be a mutual combat situation. And the state's recommending a $2,000 signature bond, no further contact with the victim, Jasmine Jones, common spelling, and no alcohol, drugs, and weapons. Nothing further, Your Honor.
All right, and Ms. McLeod or Ms. Kim? Ms.
It's
McLeod,
me, Your Honor. Good afternoon.
good afternoon.
I have no objection to the signature bond, Your Honor. My client is 59 years old, has lived in East Point and the Atlanta area all her life. She tells me she's currently not working and is pretty much homeless. So a signature bond would be good for her because she's in no position to pay for a bond.
Okay. All right. I'm going to grant the $2,000 signature bond through the jail. There will be no drugs, alcohol, or weapons while on bond, and no further contact with the victim, Jasmine Jones.
Thank you, Your Honor.
All right, if that concludes this matter, we'll be done with this case. All right.
Thank you, Your Honor.
All right, good luck to you.
Thank you.
Next, we have position 12, Ms. Tanja Smith.
All right, this is case number 22 CR 001920E. Tanja Smith, you're charged with 1 count of battery, and that offense date is March 31st, 2022. Pretrial,
Second arrest, 2005, 2 counts of simple battery, dead docket.
okay? And Ms. Mitchell,
Yes, Your Honor. In this case, the defendant battered Miss Marlene, spelled Marlene, Brown, by striking her in the face multiple times with a closed fist, leaving substantial swelling on her eye and forehead. So the defendant and Ms. Brown are neighbors and have had disputes in the past. The defendant was upset about the complaints made against her, so the defendant began knocking on Ms. Brown's door, yelling at her to open it. Ms. Brown eventually opened the door, and as soon as she opened it, the defendant started putting her hands in Ms. Brown's face. Ms. Brown brushed the defendant's hand away from her face and was immediately punched in the face. Ms. Brown hit the ground, and the defendant jumped on top of her and continued to punch her in the face several times. That's when the defendant's niece, Ms. Akira, spelled Akira, Trumpet, broke up the fight. Your Honor, the defendant and her niece stated Ms. Brown hit the defendant in the face first. However, another witness and neighbor, Ms. Yvette Garcia, states that she saw Ms. Brown touch defendant's face, and the defendant was the one who punched Ms. Brown first. She also saw the defendant standing over Ms. Brown while she was on the ground as she continued to strike her a couple more times. So based on the nature of these allegations, the state is recommending a $2,000 surety bond, no further contact with the victim, Ms. Brown, a stay away from the address 300 Dunwoody Creek Circle, Sandy Springs, Georgia, which we believe is Ms. Brown's address, and a 1-day anger awareness course, and no alcohol, drugs, and weapons. Nothing further, Your Honor.
all right, Ms. Kim,
Yes, Your Honor. Miss Smith is actually, she has been here in Georgia for 21 years, and she does have quite a bit of, actually she has a brother who lives 3 doors down from her house, basically who can testify as a witness as well. My client denies all the allegations, and actually it is completely different from her perspective. It was Miss Brown who hit my client first, and my client has been here in Georgia with 2 children, 6 and 9 years old, and she owns the house, which is right next door to 300, and she has 2 brothers right around the nearby, and she has been working as a director of school. She's actually a supervisor of a lot of teachers, and she has been working there as a director for more than 13 years. And she does not have any prior criminal except 2005, which is very, very remote for it to be considered for this case. We strongly recommend for a signature bond, because even pre-trial was recommending her for signature bond. She's qualified, and there's a misunderstanding and different testimonies about, different witnesses. So we would like to request for a signature bond, Your Honor. Thank you.
all right. I'm going to order a $2,500 signature bond through pretrial. I'm going to order the 1-day anger awareness course. I'm going to order no drugs, alcohol, or weapons while on bond. I'm going to order no further contact with the victim, Marlene Brown. And I'm going to order stay away from the address of 300 Dunwoody Creek Circle, as long as that's Ms. Marlene Brown's address. Is that correct?
Yes, Your Honor.
So I want you to understand, Ms. Smith, you're to stay away from that address. Don't go near it. Don't go in front of it, beside it, or anything, even though it may be near your house or your brother's. You need to go the other way so that you don't get arrested again.
Yes, ma'am.
And I think that's it. Is anything else I need to take up?
No, Your Honor. Nothing further.
No, Your Honor.
All right, that will conclude this matter.
Thank you.
We're completed here in courtroom 3, Judge. Thank you.
All right, thank you. Nice short day. Have a good weekend.
Oh, no, I'm still working. No, I'm still here, Judge.
Oh, you got to move to the other one. I got you.
Yes, thank you.
Okay. All right, South Annex.
Position 14, Ms. Zimmerman.
All right. This is case number 22 CR 001922E. Ms. Zinneman, make sure I'm not mispronouncing your name, is Zinneman?
Yes, ma'am.
Okay, you're charged with 1 count of battery family violence. The offense date is March 31st, 2022. Pre-trial?
Yeah, first arrest.
Okay. All right, Ms. Mitchell?
Yes. Your Honor, in this case, the defendant battered her live-in boyfriend, Mr. Kenneth, common spelling Baxter, also common spelling, by scratching his face. While Mr. Baxter was at work from 5 p.m. to 5 a.m., he received a video of the defendant taking all of his belongings out of the apartment and placing them in the public breezeway. When he got off work, Mr. Baxter went to retrieve all of his belongings and started placing them into his vehicle. While the defendant was inside the car gathering her belongings, she took Mr. Baxter's cell phone and wouldn't give it back to him. As Mr. Baxter attempted to grab his cell phone, a scuffle ensued. The defendant tried to put the vehicle in gear, and she tried to prevent Mr. Baxter from leaving, so she grabbed him and started scratching his face. Based on the nature of the allegations, the state is recommending a $3,000 surety bond, no further contact with the victim, Mr. Baxter, a stay away from the address 2524 Martin Luther King Jr. Drive, Atlanta, Georgia, if he is still living there, a 1-day anger awareness course, and no alcohol, drugs, and weapons. Nothing further, Your Honor.
All right. Ms. McLeod?
Yes, Your Honor. My client denies that she was the aggressor in this matter, Your Honor. As the court will note, my client has not been arrested. It's her first arrest. She's 35 years old. She tells me that she has been in a relationship with this gentleman on and off for some time. He moved in with her in late December, but it has not been working out. And they agreed that he would leave. And he was moving his stuff, but he did have some stuff that belonged to her, which she was trying to retrieve, and he attacked her. She has a busted lip here on both sides of her lip. You know, she was the one who called the police because she felt like she was being attacked. When the police officers came, for some reason, they arrested her. My client has no criminal history. She does have 2 young children, an 11-year-old and a 14-year-old that live with her that she takes care of, Your Honor. She's gainfully employed and has been in this community all her life. Therefore, I think she is a very good candidate for signature bond, and I would ask the court to consider giving her that.
All right. I'm going to order a $3,000 signature bond through pretrial. I'm going to order a stay away from the address of 2524 Martin Luther King Drive, Atlanta.
That's her home, Your Honor, where she lives with her kids.
Okay, where does Mr. Baxter reside?
Well, he's left there. That's my understanding, but he has only been there since December. That is her home.
Okay. The only way I want to make sure that it's clear, Ms. Zinneman, if you go back to that location and Mr. Baxter is there, you are not to go live there. You'll have to find somewhere else to live. So you can return to the 2524 MLK as long as he is not there and does not reside there. Okay?
Your Honor, can we request a one-time escort to ensure that Mr. Baxter doesn't live there?
Yes, there will be
Your belongings.
right, one-time police escort to retrieve any personal belongings if you get there and he is still there, until he vacates the location if he has not already. I'm going to order the 1-day anger awareness course. No drugs, alcohol, or weapons while on bond. Is there anything else I need to take up?
No, Your Honor.
No, Your Honor.
All right, thank you.
Thank you, Your Honor.
Mhm.
Thank you, Your Honor. May we be excused?
Yes, if that is it, have a good weekend.
Have a second question.
Good afternoon, Your Honors. Courtroom 2, Officer Norris. We got position number 1, Mr. Omarion Alexander.
All right, Deputy. This is case number 22, CR 001923J. This is Omarion Alexander, and you're charged with 1 count of battery, the 2nd count of obstruction of a law enforcement officer, both with the offense dates of March 31st, 2022. Do you have anything pretrial? You're on mute. Okay.
It's his first adult arrest.
All right. Miss, oh, is it Miss Tartarello? I'm sorry, I'm changing people, making sure I can see here. All right, you may proceed.
Yes, Your Honor. Look back up here. So, Your Honor, in this case is about the defendant, Omarion Alexander. He punched the victim, Kiara LeBron, because she did not want to purchase a water bottle. On March 31st, 2022, an Officer Crenshaw of the Atlanta Police Department responded to University Avenue Southwest and the I-75, I-85 southbound ramp in Atlanta. Upon the officer's arrival, he spoke to the victim, Miss LeBron, who stated that she was stopped at a red light on University Avenue Southwest, and she saw boys trying to sell water, so she ignored them, as she did not want to purchase any that day. LeBron stated that the defendant was aggressive and kept tapping on the window, at which point LeBron lowered her driver's side window, and that's when both parties had an exchange of words. Thereafter, the defendant punched LeBron in the face, leaving her with a swollen lip and a minor cut inside her mouth. The officer was given the defendant's identification and began to canvass the area where he eventually located the water boys and the defendant. The defendant saw police and took off running, led the officer on a foot chase, jumping over several fences and backyards. The defendant was arrested, and all these events did occur in Fulton County, Georgia. Your Honor, this defendant was arrested on February 3rd, 2021 for aggravated assault by the Atlanta Police Department. The state, as far as risk to public safety, Your Honor, the defendant attacked a motorist by punching her in broad daylight around 3:19 p.m. without care of who saw his actions. And all of this because the victim refused to purchase a water bottle. The victim has advised that she has encountered the water boys in the past and has supported their business in the past. And there's a possibility that this defendant could intimidate this victim. As far as reoffending, Your Honor, though only 2 cycles, this defendant was arrested again for aggravated assault last year, and now he has this case before the court today. This is evidence that he is likely to reoffend while out on bond and only commits and will also commit a felony offense. So the recommendation, Your Honor, is a $4,000 surety bond for the battery, and for the obstruction, a $1,000 surety bond. That would be a total of $5,000. The conditions is that he have no contact with the victim, Kiara LeBron. That's spelled Kieta. The last name is L-A-B as in boy, R-O-N as in Nancy. That he take a 1-day anger management class, no weapons, no drugs or alcohol, and no new violations of Georgia law. Your Honor, I also see the victim in this case. She's on the Zoom.
Okay.
Nothing further from the state.
All right. Ms. McLeod, do you want the victim to go before you or after you?
Before me, Your Honor.
Okay. Ms. LeBron, can you unmute yourself, please?
Good afternoon.
Good afternoon. Would you like to address the court today?
Yes, I just have a
Okay, hold on 1 second for me. Hold on.
Oh.
Raise your right hand for me. I have to
Okay.
swear you in first.
Okay.
Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
Okay, all right, go ahead. What would you like to tell me briefly about this incident?
Like I say, I know the guys, I've supported them, and I do understand how the mind, I'm sorry.
No, go ahead. I'm sorry. Go ahead.
I do understand how the mind works. I myself, like I was trying to tell the young man, had an incident. I've been working on myself 3 years probation. I am a well-being coach, and I had to take a lot of anger management classes and a lot of well-being classes at this university called the University for Parents. And it's a great program. And like I said, I've been working for 3 years and I'm about to get off. And what I realize is that a lot of us have been through a lot of trauma and different stuff, and our mindsets are just where they are. And I want him to be able to get the therapy that he needs, because like with my situation, I understand that I needed therapy. I didn't need all the criminal charges, which makes it a little harder. But then it's a thing of how do you correct behavior? And I think behavior is corrected with a mindset change. And so if I could recommend a university for parents, it's a great place. He could take a class called New Way Forward and an anger management class. And I mean, it really works, Your Honor. But that's all I wanted to say.
Okay. Are you in fear of this defendant, Mr. Alexander?
No, ma'am.
Okay. All right, go ahead, Ms. McLeod.
Your Honor, we are not going to excuse what happened. It was an unfortunate situation. My client is 17 years old. He tells me he is one of 8 children. They all live with their mom. She may well be on the Zoom too. I spoke with her earlier. He regrets the incident, Your Honor. He knows that he didn't act right. He's only 17 years old. He tells me that he's working on his GED right now, Your Honor. He doesn't have any money to post bond. So if he doesn't get a signature bond, he's just going to be sitting in jail until this comes up. The victim has stated that she is not afraid of him, and I think she does have some understanding that he needs help. And I think an anger management course would be good for him. And perhaps, just showing some other way to channel his anger and his frustration, Your Honor. I think it's not too late for him. He's just 17. Just because he has been arrested doesn't mean he has to be a career criminal. So I think it might be a good thing for him to get a signature bond and to be asked to do this course instead of sitting in jail. Thank you, Your Honor.
Okay. Let me make sure, is there anyone else on the Zoom court for Omarion Alexander? Is his mother, relatives, or anyone on the Zoom for him?
Hello.
Yes.
Yes, I'm on the line.
And who are you?
The mother,
And what is your name?
Brianna Alexander.
Okay, only way you can address me is I have to see you.
I don't want to be on no YouTube, and I don't want to be on no camera like that.
Okay, well, I cannot let you speak because I cannot verify who you are. I cannot see you.
Okay, just 1 second.
All right, can you raise your right hand for me, Miss Alexander? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, what would you like to tell the court today?
Only thing I want to say is Omarion being getting himself together. Like I say, he have been to jail previous times. He just got out probation last week. I don't know why this secured. He didn't even supposed to be back up there selling any water. I had gave him money yesterday. So I don't even know why he went up there. Sorry for the lady that, got hit. But I was told as well that she called a guy to threaten my son for him to come up there to fight. So that's why I think he maybe got aggressive. He's not raised to hit no women's. He's a child. I have 9 kids, disabled son. We don't even allow it. So whatever she said, that triggered him. Whatever help he need to get, I just hope he can get some help. But that's all I can say. All I know is he hadn't got himself together. So this secure right here yesterday, I'm just surprised. I'm very much is. That's all I can say on what just happened yesterday. I don't have anything else to say.
All right, thank you.
Your Honor, with all due respect to the witness and this court, I just want to point out that this is a biased witness, as that is his mother. And Your Honor, I also would like to point out that as the victim was speaking, I could see the swelling on her lips. You could see her injury, and that in this matter, Your Honor, there was a person who was in fact injured. So I just want you to take that into consideration in your ruling.
Okay. All right, I am going to order a $4,000 surety bond, $3,000 for the battery, and $1,000 for the obstruction. I'm going to order no drugs, alcohol, or weapons while on bond. I'm going to order a stay away from the victim, Kieta LeBron. I'm going to also order the anger awareness course, a one-day anger awareness course. And Mr. Alexander, I want you to get a hold of your emotions and your anger here. You're just getting off probation, you're going to be right back on bond. I want you to get it together. You're just 17, but you're making some bad choices if they turn out to be true, but I want you to be careful with those choices, okay?
Amen.
All right, good luck to you.
Thank
All right. All right.
you. Your Honor, next we have position number 8, Mr. Frederick Hill.
All right, position 8. This is case number 22 CR 001929Y. Mr. Frederick Hill, you're charged with 1 count of criminal trespass. The offense date is March 31st, 2022. Pretrial.
15 total. Last arrest was back in June, probation violation. He's on probation for ag assault. 19 SC 169513. The underlying charge for the probation violation was the ag assault. 2018 shoplifting conviction. 2018 possession of drug-related objects. He was arrested twice in 2018 for that. Twice in 2017 for that. 2017 failure to appear NOD. 2016 shoplifting arrest. 2015 probation violation. Underlying charge was battery. I came off a 2015 battery conviction. Got another 2015 arrest for reckless conduct, misdemeanor obstruction, battery. Those were convictions. That's it.
Okay. Ms. Tortorello.
Yes, Your Honor. Your Honor, this case is about the defendant, Frederick Hill, going back to Biltmore Apartments located at 58 6th Street in Atlanta after being given a criminal trespass warning by the Atlanta Police Department on March 17th, 2022. The offense occurred on March 31st, 2022, which was yesterday, where Officer J.W. Davis of the Atlanta Police Department was called to the scene. The defendant was arrested, and all these events did occur in Fulton County, Georgia. Your Honor, as simple as this case may be, I am recommending a $2,000 surety bond. The conditions is that he stay away from Biltmore Apartments, and that's at 58 6th Street in Atlanta, Georgia. That he have no weapons, no drugs or alcohol, and no new violations of Georgia law. Your Honor, given his record, I am opposed to a signature bond. He poses a risk of reoffending. He has a felony on his record and 15 cycles. And if I can go over it. So on June 24, 2021, he pled to aggravated assault, Fulton County Superior Court. That case number is 19 SC 169513. He took an Alford plea. He also pled to a theft by shoplifting on June 27, 2019 in Fulton County State Court. He has a violation of probation on June 4th, 2021 out of Fulton County and a failure to appear. So he poses a flight risk on March 12th, 2017 out of Fulton County, Your Honor. And for this reason, we do feel that a $2,000 surety bond is more than reasonable for this matter. Nothing further.
All right. Ms. Gant,
Yes, good afternoon, Your Honor.
good afternoon.
Mr. Frederick Hill is 29 years old. He has been in the Georgia area his entire life. He has family here. However, Mr. Hill states that he is homeless. He does have a caseworker, Ricardo Santiago, and that caseworker is working with him to help resolve some of his housing issues. Your Honor, we are unopposed to the stay away at 58 6th Street. Mr. Hill completed the 10th grade and he is unemployed and has been so for several years. He denies the allegations. He states that he was lured onto the property. He states that someone had, or the officer had a taser and told him that if he did not approach him, then he would taser him. So that is why he states that he was on that property, Your Honor. I am requesting a signature bond for Mr. Hill. He does not have the means to pay anything toward bond, nor does he have any family who is able to contribute anything at this time. Again, we are unopposed to the stay away. Thank you, Your Honor.
Okay. All right, I'm going to order a $2,000 surety bond. I'm going to order a stay away from 58 6th Street, which is the Biltmore apartment. Stay away from there, Mr. Hill, else you'll be arrested again. You're not to go back there under any circumstances. And I'm assuming you do not live there. So I'm trying to make it very clear that you are to stay away from the 58 6th Street. There will be no drugs, alcohol, or weapons while on bond. And I think that is all that I need to take up at this time. Is that correct? Anything else?
Nothing further from the defense, Your Honor.
Okay.
Nothing further from the state, Your Honor.
All right. That will conclude this case.
Thank you, Your Honor.
Your Honor, next we have position number 2 and 3, Eric Brady. Position 2 and position 3.
All right. I'm going to call case number 22 CR 001924A, State versus Eric Bernard Brady. In this case, you're charged with 1 count of battery against a female who is pregnant with the offense date of January the 8th, 2022. I'm going to also call case number 22 CR 001925A. In that case, Mr. Brady, you're charged with 1 count of battery and 1 count of criminal trespass and damage to property, both with the offense date of March 31st, 2022. Pre-trial?
12 total. Last arrest was March 2021, probation violation. February 2021, ag assault. That's open, 21 CP 197853. 2020 probation violation. 2020 felony theft by receiving. He's on probation for robbery by sudden snatch, theft by taking. It's 19 SC 169152. He went to felony earlier and received no bond, from what I was told. That's it.
All right. Ms. Tartarello?
Yes, Your Honor. For the simple battery against a pregnant female, I'm going to go over the facts first, or how would Your Honor like me to proceed with this?
That's fine. Go ahead.
So in this case, Your Honor, the defendant, Eric Brady, senselessly beat on a juvenile victim, initials KL, to the point that KL passed out in front of her mother, Lavette. Your Honor, on January 8th, 2022, an officer G. Kirk of the Atlanta Police Department responded to 2209 Penelope Street Northwest in Atlanta. Upon arrival, the officer met with the witness and mother of the victim, Lavette, who stated she was watching television inside her home when she heard screaming. Alarmed, she went outside to see what was happening and witnessed her daughter, the victim, KL, being helped towards the house by her best friend. Ms. Levette said she witnessed her daughter pass out in the neighbor's yard. When KL was brought in the house, she stated she had stomach pain and back pain and had trouble breathing. Grady arrived to provide the juvenile with medical assistance. The officer attempted to speak to KL, but she was not able to communicate properly. The officer was advised that KL and her friend were at the corner of Verbena and Penelope Street when the defendant came up to KL and began punching her in the stomach several times before running from the location. While speaking to the victim's mother, Ms. Levette, the defendant called the best friend's mother, where the officer heard the defendant stating that KL was pregnant, and that was the reason he punched her in the stomach and admitted to wanting to terminate the fetus. Upon hearing this from the defendant, APD Homicide Unit was advised of the matter, and the victim was transported to Eggleston Children's Hospital. On January 13th, 2022, an investigator Skidmore returned to the incident location where he was advised by Ms. Levette that the defendant had returned 3 days after the incident date and pointed a gun at her. She also advised the investigator that the victim was not pregnant at the time of the incident. And all these events did occur in Fulton County, Georgia. Your Honor, for the other case involving the battery and the criminal damage to property, this case again involves the same defendant, Eric Brady, kicking the front door open of victim Zaria Walker. The victim was scared. She was holding a pistol in her hand. The defendant successfully was able to enter her residence, where he violently pushed and shoved the victim, which resulted in the victim's lip to split open when the pistol she was holding struck her mouth due to the defendant's actions. Police were called on March 31st, 2022, and were dispatched to Ms. Walker's home at 3003 Middleton Road in Atlanta, Georgia, around 6 a.m. And these events did again occur in Fulton County, Georgia. Your Honor, the state has concerns. I'm going back to the simple battery on a pregnant female case before us. So currently right now, Your Honor, we are actually working to confirm that in fact the victim was not pregnant at the time. If that in fact is true, we're waiting on medical records. We're going to downgrade it back to a battery. However, this case is under investigation for a felony transfer, as the victim was a juvenile for a cruelty to children charge. For intimidating of witnesses and victims for this case, Your Honor, you've heard the violent nature of this case and the statements that the defendant stated over the phone. To add, Your Honor, we were able to get in touch with Ms. Levette, who stated to us that her daughter is no longer in a relationship with this defendant, that ever since the defendant and her daughter broke up, he has been threatening and harassing them. The victim stated a few days after this incident, the defendant came back to her home and pointed a gun at her and threatened to shoot her. The victim also stated that he has done this multiple times. She further stated after this incident, the defendant broke into her home twice and shot at her house and busted her windows. And the victim and her daughter are very afraid of the defendant. To add, Your Honor, as far as risk of reoffending and committing felonies while out on bond and a risk to public safety, this defendant is in fact a risk to public safety, and we have concerns that he will reoffend. He has current case of 22 CP 207956, incident date January 11th, 2022. It involves the victim's mother, where the defendant pointed a black handgun at Miss Levette, where he threatened her to tell whoever was in her house to come out because he was going to kill him and shoot him. And this was filed today. 22 CP 207957, the incident date of February 26, 2022, the defendant pointed a gun at his sister. The victim in this case, which is the victim in that case, and discharged the weapon. This was also filed today. 21 CP 197853, incident date February 3rd, 2021. The defendant threw a knife at the victim in that case, which cut her hand open and was given a bond of $40,000, which he is currently in violation of this bond, Your Honor, and is further proof he will likely violate his bond conditions while out on bond. So, Your Honor, he pled to robbery by sudden snatching in 2019 under conditional discharge, and then violated his probation due to his 2021 aggravated assault arrest. For the bond recommendation for the battery family violence offense, battery on a pregnant female, Your Honor, $25,000 surety bond. The conditions: he have no contact with the juvenile victim, KL, and her mother, Lavetta Lavette, that he stay away from their residence at 2209 Penelope Street Northwest in Atlanta, that he take a one-day anger management class, no weapons, no drugs or alcohol, no new violations of Georgia law, and that he relinquish the weapon that he currently possesses. For the second case, Your Honor, involving victim Zaria Walker with the battery charge and criminal damage to property, we are asking for a $15,000 surety bond. For the battery and for the criminal trespass, a $10,000 surety bond. Total amount is $25,000 a surety bond. Conditions is that he have no contact with victim Zaria Walker, that's spelled Z as in zebra, A-R-I-A, Walker traditional spelling, that he stay away from 3003 Middleton Road Northeast in Atlanta, Georgia, that he take a one-day anger management class, no weapons, no drugs or alcohol, and no new violations of Georgia law. My understanding is that the victim Zaria Walker is present, Your Honor. We understand that she wants contact, but the state strongly opposes to contact, given the defendant's history and the facts of this matter in both cases, and nothing further from the state.
All right. Ms. Walker, does she wish to address the court?
Yes.
Okay. Ms. Walker, you will have to turn on your camera if you would like to address the court today. All right. Okay. Do you have a child in the car with you?
Yes.
Okay. I'm not for sure that that's going to be good for you to talk in front of the child. Are you able to stand by the car and have the child stay in possibly, or somewhere so this child cannot hear what you're getting ready to say?
Well, he doesn't understand. He's only 3.
Well, you'd be surprised. 3-year-olds are pretty smart these days. And I just don't want you talking about this type of incident or things like that in front of your 3-year-old. You'd be surprised what he'll tell you later. So is there any way that you can safely handle the situation, or else I'm not going to allow you to testify in front of your 3-year-old child?
I can stand outside.
Okay, will your child be safe where you pulled over? You can see your child?
Uh-huh.
Okay. And let me see if you can turn the phone back towards you. All right, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, what would you like to tell me about this incident?
Okay, well, I mean, lately he hasn't been on his medication. He needs his medication. Like, he really needs help, and he's lost his dad. But according to that, it's like it causes him to, spaz out. We had a little argument, and, all I can say was he came towards me, and, I was kind of scared. So that's why I had my gun. And, he pushed me. He pushed me. I pushed him back. And I hit myself in the lip with my gun. And then he left, but he was trying to get back in, but I did not let him back in because I was scared. I mean, I didn't, when people mad, you never know what they can do.
All right, so are you stating that the gun was your gun and not his gun?
It was mine.
And did Mr. Brady also have a gun?
No.
Okay. And are you in fear of Mr. Brady?
No, I am not.
Does he reside with you?
He was in and out for about a month.
Okay, so at the present, he does not reside with you?
No.
And do you have any children with Mr. Brady?
No.
Okay. All right. I don't have any more questions. Ms. Tartarello, do you have any questions?
Yes, Your Honor.
Okay.
Ms. Walker, how are you?
Good.
Good. So did you call the police on the incident date?
No, it was not me. I believe I called my mom and I was telling her what was going on. Either it was my mom or it was probably one of my neighbors.
Okay, and so, but when police arrived, did you not tell them that the defendant kicked your door open?
It was almost kicked open. The maintenance people, they was trying to get in the door, but it wasn't opening. It was like stuck.
So why would
I couldn't get out.
Why would he not kick it? I mean, why would he not just knock at the door instead of kick it open?
He did knock at the door, but I did not open the door.
Why did you not open the door?
For my safety.
So you were scared?
Yes.
Okay, and why were you holding the gun?
Well, that was before he left. That was because it was for my protection. Because like I said, if people are mad, you never know what they can do. And like I said, he was on medication. He doesn't have that medication right now. So that what causes him to act like that.
So you were scared because he was out of his medication?
Uh-huh.
And how does he act when he's not under his medication?
It's like he can easily get irritated or everything upsets him. And like I said, he just recently lost his dad, so he doesn't know how to handle all that at the same time.
Have there been other incidents of concern with you and the defendant?
No.
Does he refuse to take his medications?
No. He doesn't have any.
So did he push you and then shove you?
No, it wasn't a shove or nothing dramatic. We just pushed each other back. But I had the gun close to my face and it hit me in the lip.
Okay, so what the officer stated was that you advised that he pushed and shoved you, which caused the gun to hit you in the mouth.
No.
So
No,
are you telling me that if we have video of this incident, you will not be on the video stating that?
Yes, I will not be on the video stating that. Stop.
Okay. Your Honor, if I can, nothing further from Ms. Walker, if I can just for the record, Your Honor, the cycles of violence, as you know, there's tension building phase, then the acute explosion phase, the honeymoon phase, and at the center of that circle, Your Honor, is denial. Where the victim minimizes the abuse as it did not happen, and then this actually perpetuates the cycle of violence, Your Honor. And so I just want you to take that into account. And there's nothing further from me at this time.
All right, thank you.
Your Honor.
And you can go ahead and mute yourself, Ms. Walker. Let me see if Ms. McLeod has any questions for you before you go.
I do not, Your Honor.
Do not? Okay.
I did actually speak with her earlier today.
Okay. You can mute yourself for a moment, Ms. Walker.
Okay.
Okay. Go ahead, Ms. McLeod.
Yes, Your Honor, my client is disabled. He has a bona fide disability which has been diagnosed, and he's on disability. He has a mental health disorder, and Ms. Walker spoke to it. He's fine when he has his medication and is taking his medication. But when he's not on his medication, then his behavior is affected by that. I think recently he has not had his medication to take, and because of that, he's been acting in ways that he would not normally act when he is taking his medication. I certainly have spoken with Miss Walker, who assures me that she's not in the least bit afraid of him, and she said that here today. I just wanted the court to be aware that he does not work because he's unable to. He is disabled. I would like the court to take that into consideration in setting his bond and in seeing what kind of help he can be offered. I think society does owe something to people who are disabled. They cannot be held to the same standard as we would hold someone who did not have these particular disabilities. Mental health issues are essentially out of the control of the people who are affected by them. And I think it's a clear case with my client, and I'd like the court to take that into consideration when setting his bond and setting up the conditions of this bond.
And he is how old again?
27, Your Honor.
Does he have any work history, or has he been disabled for a while?
He has been disabled, I think, since he was a teenager, diagnosed.
And do you know if he's under current treatment from a physician or a facility or anything like that?
My understanding is that he is under current treatment, Your Honor. I don't know how this whole issue of the running out of his medication happens, but it's clear that he does need to be seen and prescribed medication for his condition.
Okay. Were you going to say something, Ms. Tartarello?
Yes, Your Honor. I understand opposing counsel's position as far as mental health situation. However, Your Honor, this case is serious. We've got a situation where a juvenile was beaten in the stomach.
I do not have a gun.
Hold on. No, Mr. Brady. Mr. Brady, you're not. No, not yet. You're not to interrupt the prosecutor or interrupt the court proceedings. Your attorney is Ms. McLeod, and she will be able to speak with you and advise you. But I don't need you to be disruptive, or else we'll go ahead and cut your mic off. So please adhere to those rules, okay?
Yes.
So you're not to speak. Remember, what you say can and will be used against you. All right, go ahead, Ms. Tartarello.
Yes, Your Honor, and it's clear indicative that you've seen his outbursts right now, Your Honor. This defendant is in fact unruly. But there's one case that involves a juvenile that has been beaten to a point where she passed out. We got another subsequent case where we have a victim who was battered. And then we have 3 open felony cases, 2 which involve guns, Your Honor. So we have somebody who is not medically stable. He has guns and he's out intimidating people, shooting at people. The opposing counsel, if she would like, can file an eval to evaluate him, so that way he can get his medications. But Your Honor, in all honesty, I hope that you accept our recommendation of $25,000 surety bond for each case. Nothing further.
All right. Anything else, Ms. McLeod?
No, Your Honor.
All right, in the first case with the battery against a female who was pregnant, and I understand it's still under investigation, but as to what we have at this point, I'm going to go ahead and order the $25,000 surety bond. I'm going to order that there be no further contact with the victim, the minor, or the juvenile KL. I'm going to order no further contact with the mother, Lavetta. I didn't write down the last name correct. It's Lavetta.
Lovett, L-O-V-E-T-T.
L-O-V-E-T-T. I'm going to order stay away from the 2209 Penelope Street Northwest. I'm going to order that the defendant relinquish his weapon or any weapons that he may have. And I'm going to order the one-day anger awareness course as well. On the second case ending in 1925A, I am going to order a $15,000 surety bond. I'm going to order that there will be a $10,000 bond on the battery and a $5,000 bond on the trespass and damage to property for a total $15,000 surety bond. Going to order again the one-day anger awareness course. Stay away from 3003 Milton Road in Atlanta. No drugs, alcohol, or weapons while on bond. Also, stay away from the victim, and I think it's Zuria Walker.
Yes, Your Honor. It's like Maria, but with a Z.
Okay, Zuria Walker. And I think, is that all I need to do on that case?
Your Honor, I was wondering if the court could order a medical evaluation.
Yes, I will order a medical evaluation, and if he's already on any medication, that he take any and all prescribed medication to him currently and in the future.
Thank you, Your Honor.
Anything else that I need to take up from either side?
No, Your Honor.
Nothing further, Your Honor.
All right, that will conclude both cases for Mr. Brady.
Next, Your Honor, we have position number 4, Mr. James Robert Driggers.
Okay. This is case number 22 CR 001926C. James Robert Driggers, you're charged with 1 count of giving false name, address, or birth date to law enforcement, and as 2 counts of the same thing, giving false information or name, both with the offense date of March 31st, 2022. Pretrial?
26 total. Last arrest was back in October. Death by taking, criminal damage to property 2nd degree, criminal attempt to commit a felony, possession of tools for the commission of a crime. That's open in Gwinnett County. On probation in Barrow County, possession of meth, possession of drug-related objects. You want more?
No, I think that will be it. Ms. Tartarello?
Yes, Your Honor. This case is about defendant James Driggers giving a false name and a false date of birth to Officer M. Medico of the Alpharetta Police Department. The defendant provided a name of Willard Driggers and a date of birth of September 15th, 1982. This occurred yesterday on March 31st, 2022 at 6000 Summit Place in Alpharetta, Georgia, while the officer was conducting a trespass investigation. The defendant admitted that he gave his cousin's name to the officer so that the officer would not find out he had an active warrant for his arrest. And these events did occur in Fulton County, Georgia. Your Honor, just looking at the case and at face value, I would have not opposed to a signature bond. However, the defendant's record does not give me much confidence. He pled to possession of meth, as you heard from pretrial, last year, September 20th, 2021. He pled under his conditional discharge, which is currently pending right now. On October 15, 2021, he was arrested for theft by taking felony and criminal damage to property felony. And again, like you've heard from pretrial, it's open in Gwinnett, and possible violation of that bond order for that case. On September 28, 2021, he was arrested for possession of meth by the Barrow County Sheriff's Office, where he has been indicted. And on October 21st, 2014, he was arrested for a simple assault out of Barrow County Sheriff's Office with no disposition. He does have a record of violating probation back in 2013 out of Gwinnett County. And for this reason, Your Honor, my recommendation is a $1,000 surety bond for each charge, which would be a total of a $2,000 surety bond. And the conditions is that he have no weapons, no drugs or alcohol, and no new violations of Georgia law while he's out on bond. Nothing further.
All right, and this is Ms. Gant. I'm sorry. There you go, Ms. Gant.
Yes, Your Honor. Mr. James Driggers is 38 years old. He has been in the Atlanta, Georgia area his entire life. He has his parents here. He also is the proud father of 2 children. He has a 19-year-old and an 11-year-old son for which he pays child support. Mr. Driggers completed college. He has he has some college credits and he completed a certificate course in the area of certified customer service representative. He has been unemployed for the past 2 years, but he does have a new job waiting for him at a fire sprinkler company. We heard a lot about my client's background. However, Your Honor, these offenses are unrelated to his prior offenses. He just doesn't have the means to pay any bond. So I am requesting a signature bond on his behalf. He disputes the allegations, Your Honor. And again, I'm requesting a signature bond on the lowest bond possible. Thank you.
Okay. Anything else from the state?
Nothing further from the state, Your Honor.
All right. I am going to order a signature bond in the amount of $3,000. I'm sorry, surety bond. I apologize. A $3,000 surety bond, $1,500 on each charge. With that surety bond, there will be no drugs, alcohol, or weapons while on bond. And I don't think there was a stay away requested from the state, was it?
No stay away, Your Honor.
Okay. And obviously no victims. So is there anything else that I need to add for bond conditions?
Nothing from the defense, Your Honor.
Nothing from the state, Your Honor.
All right, that's a $3,000 surety bond, $1,500 each charge.
Thank you, Your Honor.
All right, thank you.
Next, we have position number 7, Mr. Willie Heath.
This is case number 22 CR 001928E. Mr. Willie Heath, you're charged with 1 count of simple battery with the offense date of February 21st, 2022. Pre-trial?
This is 5th arrest. He was arrested in Peachtree City on March 30th for reckless conduct. Before that was 2015 marijuana possession dismissed. Another 2015 possession of marijuana, first offender. First offender in 2014 for forgery in the 4th degree.
All right. Ms. Tartarello?
Yes, Your Honor. This case is about the victim, Dion Corley, who approached the defendant, Willie Heath, to assist him during a job fair at Goodwill when the defendant punched Corley several times. This occurred on February 21st, 2022, when Officer M. Elliott of South Fulton Police Department was dispatched to Goodwill located at 6175 Old National Highway, Suite 120 in South Fulton, Georgia. Victim Corley advised the officer that defendant charged him and started to punch him with a closed fist all over, and the defendant fled the scene. Witness Marie Champagne's statement corroborated with that of the victims. Champagne added she attempted to break up the altercation in which she injured her leg in the aftermath. Ms. Champagne complained of leg soreness at the scene. Corley advised the Goodwill Career Center was hosting an orientation to get people jobs and approached the defendant to assist him. Corley said that the defendant started to call him names, such as gay slurs, and became disruptive. Corley advised he was helping out another individual when the incident occurred. And these events did occur in Fulton County, Georgia. Your Honor, we do have public safety concern here. He just got arrested 2 days ago with reckless conduct in Fayette County. And now we have this case where he battered a stranger a month before, Your Honor. And I understand that he only has 5 cycles. However, I believe that the criminal justice system has given him plenty of chances, as he was able to plead under first offender not once, but twice. Your Honor, we do feel like a $4,000 surety bond is more than justifiable for a simple battery. The conditions is that he have no contact with victim Dion Corley. That's spelled D-I-O-N as in Nancy. Last name is C-O-R-L-E-Y. That he take a 1-day anger management class, no weapons, no drugs or alcohol, and no new violations of Georgia law while he's out on bond. Nothing further from the state.
All right, Ms. Gant.
Thank you, Your Honor. Mr. Willie Heath is 25 years old. He has been in the Georgia area for his entire life. He has family here, including his parents. We are unopposed to the stay away at 6175 Old National Highway. Mr. Heath completed 12th grade. Your Honor, at this time, Mr. Heath is unemployed and has been so for several months. He does not have the means to pay anything toward bond. He is actively seeking employment and states that he was in fact arrested on the day that he was on his way to an interview. He denies the allegations. He states that he felt threatened at that particular location. He was merely defending himself. Mr. Heath has been, has had some of his offenses dealt with under the First Offender Act. However, he enjoys the presumption of innocence in this case, Your Honor. That open reckless conduct case, he is presumed innocent as he is in this case. And I would ask that, given that we have not heard about any convictions of violence, I would ask that you grant a signature bond on Mr. Heath's behalf. And again, we are unopposed to the stay away. Thank you, Your Honor.
All right, I'm going to order a $3,000 surety bond. I am going to order that Mr. Heath stay away from the Goodwill location at 6175 Old National Highway. I'm going, and so Mr. Heath, please do not go back to that location or you will be immediately arrested. I'm going to also order a no further contact. And is it Dion Corley?
Yeah, Dion Corley. Yes, Your Honor.
The victim in this case. I'm going to order a 1-day anger awareness course. And no drugs, alcohol, or weapons while on bond. Anything else?
Nothing further from the defense, Your Honor.
Nothing further from the state.
All right, thank you.
Thank you, Your Honor.
May I speak, please?
I would advise you to remain silent. The judge has ruled and it's not likely to change your ruling. It's not likely to be helpful either.
Okay.
All right, thank you. Good luck to you.
No. Come on, Lord. Only waiting on the next question.
Where's Steve? He's already done. Position 9, Mr. Ponder. Come on, Mr. Ponder.
This is case number 22 CR 001906Y. Otis Ponder. You're charged with 1 count of criminal trespass and a 2nd count of possession and use of drug-related objects with the offense date of March 31st, 2022. Do you have anything pre-trial?
14 total. Last arrest was back in August, criminal trespass. Case number is 21 CR 004265Y as in yellow. So that's open in state court September 2020 shoplifting, 3 counts, 1 count criminal trespass arrest. That was September 15th, 2020. I got a September 13th, 2020 shoplifting. February 2020 shoplifting arrest. He pled NOLO to shoplifting and trespass from January 2020. 2019 shoplifting arrest. 2019 theft by taking arrest. 2019 criminal trespass arrest. 2019 criminal trespass conviction. 2018 shoplifting arrest. 2018 trespass, it was reduced to DC time served. What else? He got first offenders for terrorist threats and misdemeanor obstruction. Those from a 2015 case. That's it.
All right. Ms. Kim? Oh, I'm sorry. Hold on a minute. I'm sorry. Ms. Mitchell?
Yes, Your Honor. In this case, the defendant criminally trespassed at the Chevron gas station located on 1990 Donald Lee Hallowell Parkway, Northwest, Atlanta, Georgia, after being criminally trespassed at the same location on 2 prior occasions on March 23rd and March 30th. The defendant repeatedly is known to come back onto the property to harass customers for money and or lottery tickets. The store manager was able to show officer video footage of the defendant on the property screaming and yelling with profanity, stating he didn't care if the police were called and that he'd remain on the property anyways. Once detained, the defendant was found with 2 glass pipes used to smoke narcotics inside his front pockets, with both tips burnt and residue inside. Your Honor, there's a current bond of $2,000 surety on this case, $1,000 as to each count, and the state is going to request that the bond remain the same, with the stay away from this Chevron gas station and no alcohol, drugs, and weapons. You've heard from pretrial the history. The defendant has a clear history of criminal trespass, being that he was convicted of criminal trespass in 2020 and in 2019, and there's 2 counts of disorderly conduct that he was convicted for that were amended from criminal trespass charges in 2018. The defendant also appears to have 3 open cases, so that's going to be a criminal trespass case from last year, where he was given a $1,000 signature bond and he failed to appear on his plea and arraignment. It's noted that he is residentially challenged, and a criminal trespass case from 2020 and a theft by shoplifting case in 2020. So based on that, we are recommending that the bond remain the same. Nothing further.
And that bond amount was what again? I'm sorry.
The $2,000 surety bond, $1,000 as to each count.
Gotcha. Thank you.
Yes, Yes, Your Honor. Mr. Ponder is 26 years old and he has lived here in Georgia for all his life. He has families here. 1 child, he is only 2 years old, and he has 3 brothers and 1 sister, and his mother's here in Georgia, so he's not going to run away. He has ties to the community, and he finished up to 10th grade education. He also has been working. He has he's not employed, but he's trying to make a living by helping people with groceries and helping people with running little errands for everybody. So he does not have a lot of enough funds for the bond, so we would like to request for the lowest possible surety bond. First of all, signature bond is the best. However, considering the past, we would like to request for $500 surety bond, $250 for each, Your Honor. Thank you.
All right. All right, I'm going to keep the bond as it remains at the $2,000 surety bond, $1,000 on each of the charges. Excuse me, and to continue and order the stay away from the Chevron gas station at 1990 Donald Lee Hollowell Parkway. Mr. Ponder, if you get out on bond, you're not to go there. You'll wind up being arrested again. No further contact with the employees of that Chevron station. No drugs, haul of weapons while on bond. And that will conclude the ruling of the court. There's anything else that I need to take up from either side?
Yes, so, the only thing I gotta do is just put my gun
Mr.
out, right?
Mr. Ponder, I strongly recommend you not to speak at this point.
Well, your bond is a $2,000 surety bond.
Plus 10% off, right?
I'm sorry?
Yes, yes.
Need to be quiet. All right, good luck to you.
Position 10, Mr. Ronaso is next.
Okay.
Yeah.
Your Honor, we're requesting a breakout room for this case based on the nature of the allegation.
Okay, and who do we need to have in the breakout room? Ms.
I
Grace?
represent Mr. Ronaldo, Your Honor.
I'm sorry?
I represent them.
Okay.
I don't represent, I would like to be in the breakout room to learn more.
Oh, okay. All right, so Ms. McLeod, Ms. Kim, Mr. Walker, and Ms. Mitchell.
And can we also get, we do have 2 new attorneys on here, ASG.
They left.
Oh,
Mitchell.
they're not still here?
Gotcha.
Okay.
No worries.
Thank you.
Excuse me, Judge Mincy,
Yes.
what was the bond for position 7, Mr. Heath?
That was, hold on a second,
$3,000 good.
$3,000 surety bond, yes.
Thank you.
Uh-huh. All right.
Francois.
Yeah, did you get my?
Yeah, I saw it. Was number 5 on your pull sheet? Because he wasn't on mine.
You talking about Files Martinez?
Yeah.
Oh, all right.
You have him in the courtroom?
Yeah, I have them.
Yeah, he wasn't on mine. Okay.
They said he was an add-on.
Yeah, nobody told me. I'm sure the state had this.
You have to wait.
All right, do we have anyone associated with the case of this is position 10, correct?
Yes, Your Honor, position 10.
Right, Mr. Manuel, is it Reynoso? Not sure if I'm pronouncing the last name correct.
It's Reynoso, Your Honor.
Okay. Do we have anyone on the line associated with that case? All right, it's 22 CR 001918G. All right, I thought, okay. All right, Mr. Morales, do you want to address the court? You do? All right, raise your right hand for me. Do you swear or affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, tell me what you would like to state about this incident.
This incident occurred on my college campus and on a road that I frequent like 10 times a day. And it was very traumatic for me when I was just using, what we all use every day, which is a restroom. I would like to possibly have some requirement that he not return to this college campus or around this student focused area because he's not a student. I feel like he can possibly do this to someone else, and having that type of requirement would very keep me level-headed, I guess.
Okay. All right. And so you have some concerns and fears with Mr. Reynoso, is that correct?
Yes.
Okay. All right. Do you, Ms. Mitchell, have any questions of this victim?
Yes. Mr. Morales, how old are you?
I am 20 years old.
Okay, nothing further.
Okay. And do you have any questions, Ms. McLeod?
Your Honor.
I didn't hear you, I'm sorry.
I do not, Your Honor.
Okay, all right. I am going to continue with the $6,500 surety bond on this case, $5,000 on the first charge and $1,500 on the second charge for $6,500 surety bond. There will be no drugs, alcohol, or weapons while on bond. There will also, Mr. Reynoso, you are to not go back to the Barnes and Noble bookstore on the Georgia Tech campus. Do not go back there. If you're seen there, you will be immediately arrested. And I want you to have no further contact with the victim in this case. No calls, no contact, nothing. And if you see the victim, if you happen to be on campus, I was going to ban you from the whole campus because I think that you're not a student and would have no reason to be there. But the campus is pretty large and spread out through the area over by Georgia Tech. But just making sure you're not a student, is that correct? Or an employee?
That's correct, Your Honor.
Okay. So if I were to ban you from the whole campus, could you do that?
That would be incredibly difficult for me, seeing as I live like 2 blocks away, but I can certainly stay away from Barnes and Noble.
Okay, so you do live near the campus. So be careful. If you see Mr. Morales, within 200, 100 yards, anywhere around, you need to go the other way because if he sees you, he's going to call the police.
Of course.
And definitely stay away from the bookstore. Do not go there while you're on bond. No drugs, alcohol, or weapons. And is there anything else that I need to take up from either side?
May I ask a question?
Maybe. Your attorney may want to make sure that you're not going to say anything against your interest. If it's about your bond or bond conditions, I can answer that.
Yes, it was just to ensure that he can also not reach out to me asking me for more Starbucks dates and hanging out.
Asking you for what now?
Like to go to Starbucks together and hang out and go for walks and stuff, because that was happening after this alleged encounter. He's not allowed to contact me, correct?
Well, I don't normally have to say that to my victims, but if you know that there is an order for you to have no further contact with this victim, then if the victim were to do that, then you need to not respond because you would be violating your conditions. My victim is not on bond and has not been accused of anything at this point. But if it's something that you need to discuss with your attorney, do that. And we can look at some bond modifications. But right now, I'm not technically ordering the victim to not contact you, but the victim should not be doing that in order to have you to violate your bond conditions, obviously. So, Mr. Morales, if you're still listening to me, I'm assuming you will not be contacting the victim at all. Okay, but I'm not going to put that in my order. My order is just obviously directed towards the defendant at this point. Okay.
Clarification, I appreciate it.
Okay. All right. That should conclude this matter.
Thank you, Your Honor.
Position 6, Mr. Gabron.
All right. Hold on 1 second. Let me take a half a second break. Hold on 1 minute. All right, we have position number 6, is it?
Yes, Your Honor.
All right, Mr. Robert Giambron or Giambron. Not for sure. I don't want to mispronounce your name.
You pronounce it correct.
Okay, this is case number 22 CR 001927C. You're charged with 1 count of criminal trespass with the offense date of March 31st, 2002. Do you have anything pre-trial?
18 total. Last arrest was September, theft by taking. He has an open case in Superior Court. Burglary in the first, theft by taking, financial transaction, card theft, and another theft by taking. It's 22 SC 180499 on probation in state court for loitering and prowling, theft by taking. They gave him 7 months probation, February 2022 for those charges. All right, let's see. 2017 shoplifting conviction. 2016 shoplifting conviction, probation violation. 2016 disorderly conduct, obstruction conviction, misdemeanor. 2015 theft by receiving auto and shoplifting arrest. 2015 simple battery family violence, that was dismissed. 2014 affray, dismissed. 2014 probation violation. 2013 DUI. Got a disorderly conduct conviction from 2011. What's that DUI? That's it.
Okay. Ms. Tartarello?
Yes, Your Honor. This case is about defendant Robert Gambron, who trespassed on victim Kathleen Mora's property, not once, Your Honor, but twice in the same day. On March 30th, 2022, an officer, Case Spence of the Atlanta Police Department, received a call regarding a trespass at 2922 North Hills Drive in Atlanta. Victim Kathleen Mora stated she observed the defendant via a Ring camera open a closed gate from her home and enter the back at around 3:50 a.m. and then saw the defendant sit on the patio furniture. Mora said the defendant left and then returned at 4:57 a.m., peering through the front door window of her home. Mora advised the officer she did not know the defendant. The defendant was arrested the next day on an entering auto call, not involving the same victim. And these events did occur in Fulton County, Georgia. Your Honor, we have concerns that the defendant will reoffend, and not only reoffend, but commit felonies while out on bond. As you heard from pretrial, he currently has an open felony case, 22 SC 180499. The incident date was May 19th, 2021, where the defendant is charged with burglary and theft by taking, 2 counts, and financial card theft. He has a current bond of $1,500 for that case, and he's currently in violation of that bond order, Your Honor. To add, he's been convicted on September 21st, 2021 of loitering and prowling, theft by taking in Fulton County State Court. That case number is 21 CR 005006F for the record. He's also convicted in February 2017 for theft by shoplifting out of Bibb County State Court. He had another theft by shoplifting conviction in 2016 out of Bibb County State Court. And a 2016 disorderly conduct conviction out of Bibb County State Court. He has a violation of probation on his record in 2016 out of Bibb County. We also fear that he will intimidate the victim in this case. We have concerns that this defendant will intimidate the victim as he knows where she lives, and had no problem, Your Honor, not only peering through her front window, but opening a closed gate and entering the back of her home. For this reason, Your Honor, we recommend a $3,000 surety bond. The conditions is that he stay away from 2922 North Hills Drive in Atlanta, that he have no weapons, no drugs or alcohol, and no new violations of Georgia law, Your Honor. Nothing further.
All right. And give me your bond amount again.
$3,000 surety, Your Honor.
Okay, that's your recommendation. All right, Ms. Gant.
Thank you, Your Honor. Mr. Robert Gamebron is 40 years old. He is residentially challenged at this time, and we are working with our social worker services to connect him to the PAD or PAD program. Mr. Gamebron has been in the Atlanta area for 3 years. He is proud father of a 16-year-old son. He obtained a general equivalency diploma and also a degree in culinary arts. He has been unemployed for several months, therefore he is unable to make any bond at this time, Your Honor. He disputes the allegations, and despite his background, Your Honor, I am requesting a signature bond as he does not have the means to pay anything toward bond. He gave me his uncle's number, Scott Gimbron, to reach out to. I did that, but was unsuccessful. And I would bring to the court's attention that the stay away, to which we are unopposed, will accomplish will eliminate any concerns regarding the state that he will intimidate this witness. We did not hear about any allegations of violence, Your Honor, and this allegation again is unrelated to any burglary or theft claims, and furthermore, he is presumed innocent despite his background, Your Honor. Thank you.
Okay. I'm going to order a $2,500 surety bond. With that $2,500 surety bond, no drugs, alcohol, or weapons while on bond. Going to order stay away from the incident location. No further contact with the owner or the victim in this case. Give me that name again.
Yes, Your Honor. Her name is Kathleen Mora. And Mora is spelled M as in Mary, O-R-A.
Okay.
Kathleen with a K.
Thank you. And I'm going to order no further contact with Ms. Mora, that location. So Mr. GM Brom, you are not to go back to that location. You're not to be really anywhere near or around that location. And I'm sure if the victim sees you probably in her block coming down the street, she'll call the police. So you need to really stay away from that neighborhood totally. Because if you don't live there or have no reason to be around there, then you should not be in that location. No drugs, alcohol, or weapons while on bond. And I think that will conclude my order at this point.
Thank you, Your Honor.
Okay.
Thank you, Your Honor.
All right.
Next, we have position 13, Mr. Whitehead.
This is position number 13.
Yes, it is.
All right, case number 22 CR 001921F. Mr. Victor Whitehead, you're charged with 1 count of battery family violence with the offense date of March 31st, 2022. You have anything pre-trial?
17 total. No, yeah, 17 total. Last was 2017, failed to appear. Underlying charge was ag assault, felony obstruction, not prosecuted. He's on probation in DeKalb County for ag assault against law enforcement officer when engaged on official duty. 2017, they gave him 2 years to serve and 8 years probation. 2016, driving without a valid license, fleeing an officer. Those charges were accused, and later on he was found guilty of them, or pled guilty. 2016, probation violation. 2015, probation violation. 2012, violation of probation. 2010, same thing. Another 2010, same thing. That's it.
Okay. I'm sorry, Ms. Mitchell.
Your Honor, in this case, the defendant battered his roommate, Miss Desiree, spelled Deserae Johnson, by pushing her into a door and grabbing her by her hoodie collar and throwing her to the ground, causing her to hurt her wrist and leaving a laceration on her ankle. The defendant was already in the process of moving out and was supposed to be fully moved out by April 1st. A dispute began between the two when Ms. Johnson left to go get detergent to wash her clothes, and when she came back, the defendant was washing his clothes. Ms. Johnson took the defendant's clothes out of the...
Quiet.
I'm sorry?
I'm sorry.
The defendant... It's okay. Ms. Johnson took the defendant's clothes out of the washer since the defendant hadn't paid any utilities, and the dispute escalated when the defendant pushed Ms. Johnson into a door near the washer. Ms. Johnson struck the defendant in self-defense. That's when the defendant grabbed her hoodie collar and slammed her into a wall and threw her to the ground, causing her to hurt her wrist and suffer a cut on her ankle. The defendant denied any physical altercation from himself and Ms. Johnson. However, Ms. Johnson's injuries and her stretched out hoodie collar was consistent with her story. The state is recommending a $4,000 surety bond on this case, along with no further contact with the victim, Ms. Johnson, a stay away from her address 565 Wells Street, Southwest, Atlanta, Georgia, a one-day anger awareness course, and no alcohol, drugs, and weapons. Your Honor, our concern here is defendant's risk-free offending. He is a convicted felon with a history of theft, but I'm only going to highlight his violent crimes, which was him being convicted of aggravated assault against a law enforcement officer in 2017. We also have flight concerns, being that the defendant was convicted of fleeing in 2017, and he has a FTA in 2017, along with 6 probation violations. Your Honor, our victim advocate had an opportunity to speak with Ms. Johnson, and she states that Her and the defendant have never been in a relationship. They're strictly just roommates. He has not and still hasn't paid the remaining balance to stay at the apartment. So that's why they agreed for him to move out to begin with. She also states that she wants no contact with him. She does want to stay away from the residence, and she wants the defendant to return her key. She also stated that she filed for a TPO yesterday against the defendant, and she is on Zoom. So if Your Honor may sound for her when you're ready, that'd be great. Nothing further.
I see, is that Ms. Johnson? Are you still with us? For the case against Victor Whitehead, Ms. Johnson, are you still with us?
Yes, ma'am.
Okay, do you want to address the court?
No, ma'am. No, Your Honor, I'm sorry.
Okay, all right. We will respect that. All right, go ahead, Ms. Kim.
Yes, Your Honor. Mr. Whitehead, he is actually 35 years old, and he has been here in Georgia more than, if I remember correctly, 21 years old. More, I think he was born and raised here. He does not object to no further contact, stay away. He understands. Only thing that he asks for is one time law enforcement officer escorted visit to the place just to gather the clothings. He already moved out, but he could not finish up getting the clothes because they were on, actually he was doing the laundries. So other than that, he's very willing to stay away, and he's willing to give the keys and everything else. And he was born in Athens, Georgia, and he has 2 jobs. He works as a barber. He owns his own business in Decatur, and he also works at night at Amazon.com as a delivery. And also he graduated from high school. He went to UGA, University of Georgia, in Athens, and he has business study. He's still currently in school for CEI Health School to be a barber instructor. Currently, he's a master barber. He would like to request for the signature bond, and yet, considering the fact that there was other previous histories, we would like to request for $1,000 surety bond, Your Honor. Thank you.
All right. I'm going to order a $4,000 surety bond. No further contact with the victim, Ms. Johnson. Stay away from 565 Wells Street Southwest. And I don't know if he needs a one-time escort there to get a personal item.
Yes, ma'am. I need to
Just
get
one time.
That's just one day. That's all.
Okay, I will order that, and you will have to coordinate that with the law enforcement, but you cannot go back there unless you have law enforcement with you. So beware of that, Mr. Whitehead.
Yes, ma'am. Yes, ma'am.
I'm going to order a one-day anger awareness course. And no drugs, alcohol, or weapons while you're on bond, okay?
Yes, ma'am.
All right. That should conclude this case unless either attorneys.
How much was that?
That was a $4,000 surety bond. 4,000.
Last case, Judge, position 5.
Oh, he wasn't on my pool sheet, Judge, so I don't have a file.
Oh, he was not?
He wasn't on mine.
Okay.
I'm sure the state had it, though.
Yeah. Do you have that, Ms. Mitchell? You've got his.
Yes, I do.
Okay.
So, would you like me to start, Your Honor?
Hold on.
You gotta call the case.
Second, yet. Oh, that's okay. This is case number 22 CR 00193 Is it Martinez? Is it Files?
Files.
Files. All right. Sorry about that. I was trying to change it. I apologize. Mr. Files, you're charged in 1 count of theft by receiving stolen property and a 2nd count of expired or no license on person both with the offense date of March 31st, 2022. Ms. Mitchell, would you like to tell us about criminal history?
Yes, Your Honor, the defendant is a convicted felon. He has 42 cycles in Georgia. He does have an extensive violent history, but I'll just highlight the relevant history in relation to the charges before him today. He was convicted of theft by deception and theft by receiving stolen property in 2016. He was also convicted of driving without a valid license in 2019 and 3 separate counts of driving with a suspended license between 2014 and 2018. He also has 4 failure to appears and more than 10 probation violations, along with several parole violations.
Okay. And now you want to go ahead and present your case as well?
Yes, Your Honor. In this case, the defendant had a stolen Georgia tag, plate number CHB 1281. Property of Miss Zita, spelled Zita Davis. The defendant attached a stolen tag that belonged on a 2021 red Toyota Corolla and put it on his 2009 red Toyota Corolla. The defendant didn't have a valid license to drive when approached by the police at the time. Instead, he provided a Department of Corrections ID card. Your Honor, there's a current bond of $10,000 surety, $5,000 as to each count on this case, and the state requests that that bond be reduced to, as to count 1, a $3,000 surety, and count 2, a $1,000 surety, totaling $4,000 surety bond, along with conditions of no driving and no alcohol, drugs, and weapons. Nothing further, Your Honor.
No?
Yes, Your Honor. Mr. Files is actually, he claims that he does not understand why he was charged for the car. The theft part is that it's not even his car, and he was not aware that it was stolen from somebody. He didn't know that the car had a wrongful registration or tag numbers, so he's denying that incident, that allegations. He's been here in Georgia for 52 years. He was born and raised here, and he's working at All American Tree Services right now. And because he has 5 grandchildren and also 3 his stepchildren, he's trying to seek another second job to support those minors. And he doesn't mind about stay away or no further contact with a Walmart, but he has a GED and he has 2 years of college at technical college, but because of his responsibility, he would like to request for a little bit lower bond, up to $1,000. Thank you, Your Honor.
Okay. And you said he was how old again?
52 years old, Your Honor.
Okay. All right, I'm going to go with the state's request and reduce the bond from $10,000 to $4,000, which that will be a surety bond. $3,000 on the first charge for the theft and $1,000 on the no license on person. So that'll be a total of $4,000. I'm going to order no drugs, alcohol, or weapons while on bond, Mr. Files. And I'll say no driving until you have a valid license from DDS. So if you don't have a valid license, then you should not be driving, because you'll get picked up again and brought back to the Fulton County Jail. And obviously no switching of tags or anything like that. And I think that will conclude my ruling. Anything else, Ms. Mitchell or Ms. Kim?
No, Your Honor.
Okay.
Nothing further.
That should conclude this case.
Thank you, Your Honor.
So much.
We're completed here.
All right, thank you, Deputy.
All right, thank you. Have a good one.
Have a good one.
Thank you.
All right, Ms. Grace.
I'm ready, Judge.
We're ready when you are.
Okay, position number 1 is a $4,000 sign-on bond through pretrial. We set further notice. Position number 2.
Hold on, number 1 was a good bond, right?
I know. Hold on. No, that was a surety bond.
That's
Number
what I
one.
have.
Anybody else with me? I don't know. Sometimes I write.
4,000 good, 4,000 good.
Yeah, I thought
Yes, it was a good bond.
Yeah.
Yeah.
Position number 2 and 3. Position number 1 is a $25,000 good bond.
Well, if you could just call it and say position number 2 is a $25,000 good bond, and we don't need to say, we can just.
Reset dates. Okay.
Mm-hmm.
Number 3, $15,000 good bond. 4, $3,000 good bond. Position 5, $4,000 good bond. Position 6, $2,500 good bond. Position 7, $3,000 good bond. Position 8, $2,000 good bond. Position 9, $2,000 good bond. Position 10, $6,500 good bond. Position 11, $2,000 sign-on bond through jail. Position 12, $2,500 pretrial. Position 13, $4,000 good bond. Position 14, $3,000 pretrial.
Okay. Make sure on position 9, I wrote a 2 and a 1 for 3, or did I write it wrong? What does everyone else have on position 9? Is it 2,000 or 3,000?
I got 2,000.
I got 2,000, 1,000 for each charge.
1,000 for each. Okay.
Yeah.
And I'm so sorry. Can you repeat position 2 and 3 again? I missed it.
Okay.
Position 2, $25,000 good bond. Position 3, $15,000 good bond.
Okay, and we're going to reset that to the competency calendar because I believe a evaluation order is going to be submitted.
Right. Yes,
Okay.
that is correct.
So for 4/14 competency calendar, it's good.
If that's the first available one, yes, ma'am.
Okay.
Is it?
Yep, I believe so. Anything else, Miss Grace?
That's it.
All right. Sounds good, everyone. Enjoy your weekend.
Thank you, George. You
Thank
too.
Stay pollen free. It's getting me, I tell you.
Me too.
If you can. Yeah, I know. All right, everybody take care.
Bye.
All right, bye-bye.